This is Barry Salma speaking for Claim School Incorporated's blog, Salma on Insurance. Today we explain why a CGL policy is not a course of construction policy and why damage before project is complete is excluded by a CGL's Course of Construction Exclusion. In Liberty Surplus Insurance Company versus Kaufman, Lynn Construction, Inc., the United States Court of Appeals for the 11th Circuit on March 5, 2025, dealt with the Course of Construction Exclusion in a commercial general liability policy. The consolidated appeals to the 11th Circuit were to decide, 1, whether an insured has standing to seek reformation before it makes a claim on the portion of the policy that it wants reformed, 2, construe an exclusion in a commercial general liability policy under Florida law, and 3, determine whether the district court properly denied the insured's motion for attorney's fees. The case involves JM Family Enterprises, who hired Kaufman to build a new corporate campus in South Florida. Kaufman obtained a commercial general liability policy from Liberty Surplus Insurance to insure itself and its subcontractors. After Tropical Storm Eta caused significant water damage to the completed buildings, Kaufman sought indemnification from Liberty, which was denied based on the policy's Course of Construction Exclusion, or COCE. Liberty then filed a declaratory judgment action, and Kaufman counterclaimed for declaratory relief, breach of contract, and reformation of the insurance policy due to a mutual mistake. JM Family Enterprises had hired Kaufman to build its new corporate campus in South Florida. The campus was to consist of 3 office buildings, a training and conference center, a sports and recreation building, a dining hall, an amphitheater, a central energy plant, a parking garage, and various landscaping and water features. To insure itself and its subcontractors, Kaufman only obtained the Liberty CGL. The district court granted Liberty's motion for summary judgment, concluding that COCE excluded coverage until the entire project was completed. The court also dismissed Kaufman's reformation counterclaim for lack of standing. On appeal, the 11th Circuit reversed the district court's dismissal of the reformation counterclaim, affirming that Kaufman had Article III standing to seek reformation. However, the court affirmed the district court's ruling that the COCE precluded coverage for the water damage and denied Liberty's motion for attorney's fees. The Course of Construction Exclusion in the insurance policy issued by Liberty Surplus Insurance Corporation to Kaufman Lynn Construction, Inc. was significant because it determines the scope of coverage during the construction phase of a project. The COCE states that the insurance does not apply to any property damage at or to any project insured under the policy during the course of construction until the project is completed. A court of equity has the power to reform a written instrument where, due to a mutual mistake, the instrument as drawn does not accurately express the true intention or agreement of the parties to the instrument. A mistake is mutual when the parties agree to one thing and then, due to either a scrivener's error or inadvertence, express something different in the written instrument. Reformation can correct a mutual mistake in the description of premises or articles insured due to the fact, in the case of a mere mutual mistake in the description of the subject matter, equity will correct it to confirm the intention of the parties. Florida law, however, subjects reformation cases to a 5-year statute of limitations. An insured in Florida may need to bring a reformation claim soon after the issuance of the policy containing the mistake, or risk forever losing the ability to fix the error. The policy issued by Liberty to Kaufman was only a general commercial liability policy. It was not a builder's risk policy. The critical language in the COCE is the phrase, quote, until project is completed, close quote, but the terms project and completed are not necessarily defined in the policy. The language, however, until the project is completed, means that the COCE precludes coverage and until the entire project is finished. It would have been better, of course, for Liberty to draft the COCE to expressly state that there's no coverage unless and until the, quote, entire project, close quote, is completed. But Liberty's failure to adhere to the standards of impeccable draftsmanship here does not result in ambiguity. The mere fact that a provision in an insurance policy could be more clearly drafted does not necessarily mean that the provision is otherwise inconsistent, uncertain, or ambiguous. The 11th Circuit concluded that Kaufman had standing to seek reformation of the policy, and the 11th Circuit therefore reversed the district court's dismissal of the reformation counterclaim and remanded to the district court for further proceedings. However, with respect to the parties' dispute about the policy, the 11th Circuit affirmed the district court's ruling that the COCE precluded coverage for the water damage to the buildings caused by Tropical Storm Eta. In my opinion, a course of construction policy is designed to protect the owner and contractors for fortuitous losses in the course of construction, like a hurricane. A commercial general liability policy is not intended to and has no wording or similar language to a course of construction policy. The claims were for damage to the property that would be the subject of a course of construction policy, but not a commercial general liability policy, especially one with a COCE, since hurricanes are not caused by anyone other than God or nature, and therefore there would be no potential for coverage under a general liability policy unless by reformation the intent of the parties was to make the CGL a course of construction policy. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also receive notice of and access to the more than 5,000 blog postings. If you view the videos on rumble.com or youtube.com, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com, and please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee my Substack publications. Thank you for your attention.